At what point does getting overturned become a disqualification and not just a hobby? This judge's record, it's basically a highlight reel of legal faceplants. Botched the 11th Amendment, freed a sex abuse cover-up enabler. Even his own party once said no thanks. So why's he back? Let's unpack the circus.
Congratulations to all of the nominees. Judge Mahalchek, you remember a case called Yentzer v. Potter County?
I have a recollection that I presided over that case. I don't know if I recall the details of it.
Okay, and you were reversed, is that right?
I believe that was a case that I issued. I was a magistrate judge in that role and in the referral role on it, and it was reviewed by the district court, yes.
And you were reversed, right?
I don't recall in that case if the report and recommendation was adopted in full or not adopted in full, but yes.
The higher court said you incorrectly analyzed qualified immunity and you incorrectly cited the 11th Amendment. Do you remember a case called Myers v. Clinton County Correctional Facility?
I recall that case as well.
And you were reversed in that case too, weren't you?
I believe it was adopted in part, yes.
Do you remember a case called Dennis v. Sheridan?
Yes, I believe I recall that case as well.
And you were reversed in that case too?
I believe that R&R was not adopted in full, correct, yes.
Okay, but you were reversed.
It was not adopted, yes,
Is that
by
the
the
same
district
thing
court.
as being reversed?
It's a different, the district court declined to adopt the report and
The
recommendation
higher court
in
said
full.
you were wrong.
The district court disagreed with my report, yes.
Yeah, okay. Do you remember a case called Shania v. East Pennsboro?
Yeah, the Shanias are pro se plaintiffs who have brought a number of cases, so I'm not sure which one you're referring to, but yes.
I'm just curious, you were reversed in that case too, were you not?
In part, yes.
Okay. Do you remember a case called Spanier v. Libby?
Yes, I do.
The president of Pennsylvania State University was convicted of covering up child sex abuse crimes. And you let him go on a habeas corpus petition. And the Third Circuit reversed you, is that right?
I directed that a new trial should be held with a different jury instruction, and the Third Circuit disagreed and found that he had received the due process he was entitled to, yes.
Well, the Third Circuit said you failed to cite, analyze, or properly apply the relevant case law. You were reversed, right?
The Third Circuit reversed my decision, yes.
Okay. Do you remember a case called Hassel v. Centric Bank?
I vaguely recall that case, yes, Senator.
You were reversed, weren't you?
I believe the district court failed to declined to adopt my recommendation, yes.
Do you remember a case called Ramsey v. Amtrak?
Yes, I do.
And the higher court reversed you in that case too, didn't they?
The district court concluded that I was correct in finding that the petitioner did not pay a filing fee, and where I had recommended that the case be dismissed, he granted the petitioner 30 days to correct that.
So you were reversed in part?
Yes.
Okay. Do you remember a case called McCracken v. Fulton County?
Yes, I do.
You were reversed in that case too, weren't you?
I believe that was in part, yes.
You remember a case called Bird v. Britton?
I do.
And were you reversed in that case?
In part, yes.
Okay. You remember I'm sorry. You remember a case called Allen v. Lackawanna County Board of Commissioners?
I believe I recall that case, Senator.
And you
I'm not
were
sure.
reversed in that case too, weren't you?
I believe I was reversed in part in that case, yes.
You remember a case called Daniels v. Capital One Bank?
Yes.
And I believe you were reversed in that case too?
I believe it was, yes, I believe so.
Do you remember a case called Downey v. Pennsylvania Department of Corrections?
Yes, I recall that case.
And were you reversed in that case?
Yes, I believe I was.
Remember a case called Rejean v. Wetzel?
I vaguely recall that case, yes, sir.
And were you reversed by our court there too?
I believe that our report and recommendation was not adopted in full.
Okay, I don't have time to finish this list. I mean, it's longer than King Kong's arm here. You've been reversed a lot. In fact, you've been nominated before, haven't you?
No, I have not, sir.
Well, your nomination was talked about, and Senator Toomey refused to send in a blue slip for you, did he not?
I'm not sure exactly what happened. I know that this process has been ongoing for 2 years.
Yeah, but you know that Senator Toomey refused to even, thought you were so unqualified that he refused to even allow the Judiciary Committee to consider you. Isn't that correct?
I do not know what Senator Toomey's reasons were. So
You've never talked to Senator Toomey about it?
I never discussed it with Senator
And
Toomey.
you don't
no.
know anything about a blue slip being withheld on you?
I do not know.
You're under oath.
I am under oath, and I know I did not speak with Senator Toomey about his reasons for not.
Was Senator Toomey's concern that you were unqualified?
Again, Senator, I did not speak with Senator Toomey or his staff about his reasons for not supporting me.
Okay. Thank you, Mr. Chairman.
Watching Judge Maholchek stumble through that hearing was like watching someone apply for pilot school while casually admitting they've crashed every flight simulator. The man wasn't just reversed by higher courts, he was practically on a first-name basis with the appellate system. Yensler, Myers, Dennis, Spanier, McCracken, Downey, the list reads less like isolated judicial missteps and more like a greatest hits album of legal blunders. Now, look, reversals happen, but this wasn't an occasional course correction. This was a pattern, a relentless courtroom-to-courtroom reminder that when Maholchek sits on the bench, constitutional rights tend to land in a ditch. And the Spanier case? That wasn't just a poor ruling, it was judicial malpractice with national headlines. A Penn State president convicted for helping bury a child abuse scandal, and Maholchek saw fit to hand him a legal escape hatch over technicalities. The Third Circuit had to step in like exhausted babysitters cleaning up after a toddler tantrum, reminding him that yes, due process still applies even when the defendant's friends wear expensive suits. But here's where it gets laughable, if it weren't so infuriating. Maholchek didn't own it. He spun, he twisted. Suddenly, these weren't reversals. They were partial agreements, technical clarifications, nuanced differences. Please, if legal reversals were Olympic events, this man would be hanging gold medals on his robe. And just when you think the tap dancing couldn't get more brazen, Maholchek delivers the coup de grace, playing dumb about why his last nomination evaporated like smoke. Senator Toomey, a Republican, wouldn't even submit the blue slip. That's the senatorial equivalent of your own team benching you during warm-ups. And Maholchek's defense? He shrugs, claims he doesn't know. Either the man is a master of willful ignorance, or he's hiding something that even Toomey couldn't stomach. Here's the bottom line. Lifetime appointments require more than legal credentials. They require trust, clarity, competence, three things that, based on this record, Maholchek couldn't locate with a search warrant. You don't get promoted for failing upward, especially not when constitutional rights and justice for abuse survivors are on the line. What do you call a judge who sided with a convicted child abuse enabler, only to get unanimously shredded by the Court of Appeals? You call him Judge Maholchek, and somehow he's still chasing a lifetime seat. This isn't just bad judgment, it's a walking red flag. Let's break it wide open.
Judge Maholchek, I want to talk to you about a case you've already discussed considerably, which is the Spanier versus Libby case. That's a case involving Graham Spanier, the former president of Pennsylvania State University, who was investigated, terminated, subsequently criminally charged for his role in covering up the child sex abuse crimes committed by Jerry Sandusky. The sentencing memo written by the prosecutors in that state case noted that Spanier had, quote, shown a stunning lack of remorse of his victims. It further called for him to be punished for, quote, choosing to protect his personal reputation and that of the university instead of the welfare of children. It further highlighted that Spanier, quote, was the ultimate decision maker when it came to reporting Sandusky. Your decision in that case was reversed unanimously by the Third Circuit. Is that correct?
A three-judge panel of the circuit reversed my decision, yes.
Unanimously.
Yes.
The Third Circuit concluded that, quote, under clearly established federal law, state courts have considerable latitude to rule on the meaning of statutes. Yet you construed the rule more narrowly than the state courts to Spanier's benefit. Jerry Sandusky was an evil man, and Spanier, the ultimate decision maker, protected his own reputation at the expense of the children. Why did you deviate in your decision from clearly established federal law, particularly when it had the effect of protecting such a man?
Senator, the crimes of Jerry Sandusky are beyond horrible. They are unspeakable, and as a member of the community and as a mother of two children, they are the worst nightmare for most parents. That was not absent from my mind when I was looking at the case before me. The issue before me was whether the petitioner, who I looked at and treated as I would every habeas petitioner that comes in front of me, received due process in state court. I determined that there had been a violation of his due process rights in the use of the jury instruction that the state court had, and the Third Circuit disagreed with me.
The Third Circuit did more than that. Did the Third Circuit criticize your opinion for not only omitting relevant precedents, but also for not closely analyzing the case law that you did cite?
I can't recall verbatim what the Third Circuit opinion said. As I recall, there were three cases involved in that case in terms of precedent, and I relied more heavily on one of them than the other two.
Do you recall the names of those three cases?
I know one was the Bowie case. I can't recall the names of the other two.
Well, here's what the Third Circuit said, quote, the district court cited Bowie and Rogers but did not examine them closely, nor did it mention Metrish. Now, I do find it a little bit amazing. You knew in this confirmation hearing you'd get asked about this case.
Yes, Senator.
I find it actually quite remarkable that for this hearing, you still don't even know the three cases the Third Circuit said were critical to resolving the issue of law.
Senator, I reviewed 10 years of work in preparing for this hearing. I don't recall those three cases specifically.
So you didn't have an inkling that you would get questioned and questioned pretty vigorously about a decision with egregious consequences that was unanimously reversed by the Court of Appeals?
Did I have an inkling that I would be questioned about the Spanier case? Yes, Senator, I did.
Let me ask you this. Did then Pennsylvania Attorney General and now Democrat Governor Josh Shapiro praise the Third Circuit's reversal of your opinion?
I don't know what his comments were following the issuance of the opinion.
Well, I will point out that he released a press release, statement by the Attorney General Josh Shapiro on the U.S. Third Court of Appeals ruling reinstating the conviction of Graham Spanier, and you can read that, and he was effusive in his praise. There's a long and unfortunate pattern in this administration of Joe Biden nominating individuals to serve on the bench who have a repeated pattern of showing excessive leniency to criminals, of releasing violent criminals from jail, of releasing murderers from jail, of releasing rapists from jail, of releasing those who committed child sexual assault from jail. I don't believe doing so is in the interest of the American people. I think it is contrary to the views of the constituents of just about every one of ours. But nonetheless, that pattern continues, and the consequences are deeply harmful.
Watching Judge Maholchek attempt to defend her record felt less like a confirmation hearing and more like witnessing a masterclass in legal amnesia. Here we have a nominee seeking a lifetime seat on the federal bench, yet when pressed on one of the most consequential, high-profile rulings of her career, she drew a blank. Let's talk about Spanier versus Libby, A case that didn't just land on local news, it rocked national headlines. A case tied directly to the institutional rot at Penn State, where Graham Spanier, the university president, helped bury reports of Jerry Sandusky's child sex abuse to protect the school's image. Spanier was convicted. The victims' families wanted accountability, and Maholchek, she handed him a legal escape route, granting his habeas petition on shaky ground so thin the Third Circuit had to sweep in and shred her ruling apart, unanimously. But it's not just that she got it wrong. It's that she couldn't even name the key legal precedents that the higher court used to obliterate her decision. Not obscure, dusty cases from law school, but Bowie, Rogers, Metrish, the foundational rulings at the core of why the Third Circuit overturned her. That's not forgetfulness. That's malpractice wearing a black robe. And let's not pretend this was a fluke. It fits a pattern so glaring it might as well come with sirens. Reversals on major constitutional questions, decisions that lean suspiciously soft on violent offenders, and of course, the now infamous blue slip rejection from Senator Pat Toomey, her own home state Republican, refusing to support her the last time around. Funny how that little detail keeps vanishing from her narrative. But here's the most infuriating part. She's still being floated for a promotion, despite the judicial faceplants, despite the Spanier debacle, despite a hearing performance that looked like it was prepped by a team of interns with a magic 8-ball. And behind it all, an administration hell-bent on stacking the judiciary with nominees critics say prioritize ideological leniency over basic legal competence. This isn't just about one bad ruling. It's about what happens when sloppy reasoning, selective memory, and political favoritism collide in our courts. The victims deserve better. The Constitution demands better. And frankly, so does basic common sense. Let's be crystal clear. This isn't some paperwork mix-up. It's a glaring reminder that when you forget the victims, but remember how to shield the predators, you've got no business sitting on the bench, let alone climbing higher. We're watching the quiet corruption of our courts, one lenient ruling, one evasive hearing, one forgotten precedent at a time. But here, we don't forget, we expose, we call it out, and we make damn sure the people responsible feel the heat. So smash that like button, drop a balance symbol in the comments if you believe the vulnerable deserve more than excuses, and subscribe, because at Malcolm Varon Talks, we're not done torching the cozy club that thinks it can sneak this nonsense past the public. More hearings, more hypocrisy, and yes, more truth. Stick around. It only gets bolder from here.